Thanks for joining us. Again, hot in the news over the last couple of months was the FTC, which was really about a year and a half ago. The FTC announced a proposed rule to ban non-compete agreements in most industries, in most cases, for post-employment. That rule came to pass by the FTC earlier this year and was scheduled to go into effect in September. So right when the rule was announced in April, we did a webinar shortly after that and talked about the rule generally. If you have questions about the rule, want to get an overview of that, please refer back to that webinar and check that out. During the webinar, I had a few questions, and there were some questions that had come up when the rule was first passed on how this was going to apply to healthcare. And the reason for that is because of the way the FTC authority and jurisdiction works. And I mentioned in that webinar that we could probably do an entire webinar talking about the application to healthcare businesses and entities in the context of employment. And so that's what we're doing today. I'm also going to touch on some of the other legal challenges and what the status is there. Anybody who's been following this may see that one case was a case filed by the U.S. One of the business industries for the U.S. I don't have to, the U.S. Chamber of Commerce filed a case in Texas. That case was consolidated into another case called Ryan involving a CPA firm. The plaintiffs in that case were successful in getting an injunction, but it's a very limited application injunction. It really only applies to those plaintiffs and hasn't been expanded. I fully expect that this will be the rule probably come September in most places. And just as a little preview of what's coming next, there have been some congressional actions toward banning non-competes, and there's one bipartisan action that has been reintroduced and is supported both in the House and the Senate. It's not that far along, so I'm not going to spend a lot of time talking about it, but folks should be aware that even if the challenges to this act are successful, I expect that there's a very good chance that Congress is probably going to pass something that's going to be similar to the ban that we see now. And states are also moving in that direction more and more. Maryland recently passed something. There's some other states that have passed bans. My home state of Florida tends to be pretty liberal in its enforcement of non-competes historically, although there are some limitations and more limitations keep coming along, especially in healthcare. There's limitations to how it applies to healthcare right now. So as we talk today, I'll tell you what I think is going to be the rule and how that will play out with respect to healthcare employees. Here's an agenda up on the screen. If you have questions, please shoot them to me either during the webinar, and we'll try to field them if we see them pop up, or at the end, or afterwards. You can always give me a call or shoot me an email if you have a question when you want to talk about this or anything else that we've talked about. So here's the topics we're going to talk, and we're basically going to spend a lot of time on how this applies to healthcare entities and how the healthcare businesses should respond, both if you're an employer or an employee. We'll have a little bit of fun with this because I've got a few questions that I think are going to apply in the event that there's a legal challenge that applies to a healthcare employer, particularly a not-for-profit healthcare employer. A couple cartoons to keep the levity going as we go throughout. Feel free to spend more time on those. Credit attributable to Isa and Tony. Thank you for that. All right, so as I discussed, Federal Trade Commission passes a rule banning healthcare or banning non-competes post-employment. You can still have your employees subject to restrictions on other employment they take on. You can have a no moonlighting provision. You can have, there are legitimate reasons to have employees that are working for you not work for competitors while they're working for you, regardless of what industry that you're in. You can still do other things such as have non-solicitation agreements, have strict confidentiality and non-disclosure agreements, anti-piracy provisions. You can do things to keep your current employees from competing, from people from taking trade secrets and going to other businesses and your competitors with those. There are other things that you can do to protect your business as the employer, but come September, enforcing a true non-compete agreement, you can't work for any competitor within this certain geographical range for the next 2 years, most of those are going to go away. Only in the context of post-employment, it won't apply in connection with the sale of a business. If you sell a business, you're still going to be able to have the seller of that business be restricted to that non-compete provision, as we do oftentimes now, and in some other limited contexts. So why does it come about? What's the issue with healthcare in particular? Well, there has been questions raised and some of the challenges about the FTC's jurisdiction and authority to pass this rule generally. That discussion generally centers on the fact that the FTC is a regulatory agency in place to enforce Section 5 of the FTC Act, which is a congressional act, but the authority of the FTC is limited only to certain enforcement actions of that act. The FTC has come out and said, we think that under the FTC Act, we have the authority to regulate unfair and deceptive trade practices, and we think that non-competes represent an unfair trade practice, and we're going to issue this across the board ban of post-employment non-compete agreements, and they've given reasons for that. In fact, if you want to take a look at the final rule that was published, the rule itself only comprises a couple of pages, but the rule with all the commentary is 570 pages. If you want my highlighted copy, shoot me an email, and if you ask nicely, I'll provide you that. But I do have a couple highlights out of that, and as it applies to what we're going to talk about today. The reason people question how it will apply to healthcare is because approximately 58% of all hospitals are not-for-profit. Another 25% or so are public hospitals, county, city, government-owned or run facilities. Many other healthcare organizations are set up as not-for-profit organizations, according to the IRS. And I think that the issue here is a little bit of a, maybe one person has interpreted the statute, the FTC statute, the FTC Act, and that interpretation has carried over to provide a little bit of a fallacy as to what it says. Essentially, there are certain industries that are excluded from the FTC Act, and those are, largely speaking, banks, financial institutions, and some other organizations. And there's also a definition of a corporation in the FTC Act. And the definition of the corporation in the Act, I think, is what leads to a little bit of confusion here, because under the FTC Act, you're not going to find any language that specifically exempts not-for-profit corporations. What you will find is a definition of a corporation that says that a corporation is deemed to include any company, trust, or other association, incorporated or unincorporated, which is organized to carry on a business of that or its members for profit, and has shares of capital stock or doesn't have shares of capital stock, and is organized to carry on a business for profit. And the FTC has the authority to regulate and to regulate corporations throughout the U.S. who engage in interstate commerce. So from that, people have made this sort of derived this position that a not-for-profit corporation is not subject to the Act. And as you're going to see, that language is not in the Act, and that isn't really how the FTC sees it, and it's not what's written in the Act. Here's a copy of the rule, the heading from the rule. Just want to see what this looks like. It's Part 910 in the regulations for the FTC concerning unfair methods of competition. It goes into effect right now, September 4th of 2024. Here's some language about the exemptions of the FTC. And this is what you see oftentimes, is that most or many nonprofits are excluded from the Act. But again, the Act doesn't say that nonprofit corporations are excluded. It's the way the Act defines corporations operating for profit of its members or shareholders. And the Act allows the FTC to regulate corporations. So then the question is, well, what's the application to a corporation that's registered as an IRS nonprofit? And what about healthcare entities that are organized as nonprofit entities, according to the IRS? Of course, nonprofit models in healthcare are common. And if you read the rule, what's interesting is that there are thousands of comments that were received, and the FTC discusses in its final rule publication. And the FTC spends a lot of time in the rule talking about the application and coverage in the healthcare industry in particular. And reading through it, what the FTC recognizes that there's arguments that the rules that healthcare should not apply for broad reasons such as the need to have non-competes in the healthcare industry, which the FTC rejected. Then there's an argument that because the rule would apply to for-profit entities, that it creates an unfair competition balance between for-profit and not-for-profit. It gives not-for-profit entities who are not subject to this rule an unfair advantage. And the FTC flatly rejected that argument. And then the FTC went on to discuss that many businesses that are organized by the IRS as nonprofit entities do in fact operate for profit for its members and will be subject to FTC jurisdiction. And this is where it gets pretty interesting. So this is a little bit of a joke here, but it's not, because as we know, a lot of businesses that are set up as not-for-profit organizations under the IRS code, in fact, generate substantial profits, substantial salaries for their boards of directors, for their officers, generate a lot of income that doesn't necessarily go for a charitable purpose, that goes for other purposes. And that's where the FTC has stepped in. And previously, the FTC has encountered this issue, such as regulating organizations under the Clayton Act, dealing with antitrust. There have been healthcare organizations, and one of the most notable cases, California Dental Association, went to the United States Supreme Court, where the court said that the California Dental Association, which was set up as a not-for-profit organization, in fact, operates for the benefit, not for a charitable purpose, but for the benefit of its members, and generates substantial profits that inure to the benefit of its members. And the association was deemed to be subject to FTC jurisdiction. So in a sense, we've seen this movie before, and we can see what the FTC's position is going to be. And I think we can predict from that how the courts are going to land on this ultimately, as to whether the court or the FTC has jurisdiction to regulate these healthcare nonprofits. So like any good rule, the FTC has to put some statistics in the final rule to show the potential benefits of passing the rule and why the rule was enacted. Estimates of billions of dollars over the last 10 years in savings in the healthcare industry, savings that will be passed on to patients and the public at large. All right, so this is a little bit of, again, a recap of the issue on nonprofit entities. And the interesting comment here is the FTC commissioner, Ms. Slaughter, stating that if you claim nonprofit tax status, but you're really organized for the profit of your members, you are within our jurisdiction being the FTC. And how is the FTC going to determine this? What can we look at, and how do we make the decision that this is an entity that's organized for the benefit of members that will be subject to FTC jurisdiction? Well, the FTC looks at two factors. The FTC will look at the nexus and see if there's a sufficient nexus between the activities of the organization and the alleged public purpose. If it's a nonprofit entity, it's a charitable organization, is the money that's being raised, are the activities related to the source of the money? So money is being raised, being directed towards the charitable benefit, and are the proceeds of those funds, the proceeds of those activities, are they going to be devoted to public, i.e. charitable interests and not private interests? So the FTC puts this in a couple of different ways. And again, I may even read a little bit from the rule to just expand upon how the FTC explains this, because it takes a few minutes to understand what they're talking about here. But big picture, the FTC saying, we're going to look at an organization and see if it's really the charitable organization. Just calling yourself an IRS nonprofit, if you're really benefiting a limited group of members and not the public at large, is not going to exempt you from the rule. So the FTC talks about two issues it looks at. Source of income, again, nexus between the activities and the public purpose, and then the destination of the income. Where are those proceeds going? And let me just take a little bit of an explanation of how the FTC lays this out. And the two-part test, as they describe it, is as follows. Commissioner explained that the not-for-profit jurisdictional exemption under the Act requires both that there be an adequate nexus between the organization's activities and its alleged public purpose, and the net proceeds be properly devoted to a recognized public rather than private interests. Alternatively stated, the Commission looks to both the source of the income, i.e., whether the corporation is organized for and actually engaged in the business for only charitable purposes, and to the destination of the income, i.e., whether the corporation or its members derive a profit. And this leads me to this question, and I'll touch on this again a little bit later. But if you are an organization that is registered as an IRS not-for-profit organization, and you have employees that are on non-compete agreements, and this could apply in healthcare or even outside healthcare, you have employees that are on non-compete agreements. The first question is, why do you have them on a non-compete agreement? Is it to protect your own business interests? And are those really charitable interests, or are those business interests? Most non-compete agreements need to support a legitimate business interest. And so is there a legitimate business interest for the non-compete? And is that business interest aligned with your charitable interest? I'll give you what I think is one of the most most interesting examples that I have encountered was a religious organization. There was a nonprofit organization, and it was a religious organization. Many religious organizations encourage their followers, their parishioners, their pastors and speakers to spread the message of their religion. I won't say which religion in this case, but religious organization. And this is a stated doctrine of this particular religion, is to spread the message and spread the word of the religion. A pastor wants to leave the organization and has a calling to go create their own separate organization, which would technically compete with the organization, that the religious entity that the pastor was working for. And the pastor is subject to a non-compete. How is that non-compete agreement? If the organization's purpose is to spread the word of the religion, spread the doctrine, and somebody wants to leave and has a calling to spread that doctrine, and this is part of your charitable mission and purpose, then how is it a legitimate business interest supported by restricting somebody from doing exactly what your doctrine says you're supposed to do? I don't know how you defend that. And you can only imagine, I can imagine especially, what discovery would look like in a case like this. If I'm representing an employee subject to a non-compete with a nonprofit, I would think that in litigation, if we're going to dig into whether or not the organization is subject to FTC jurisdiction, thus rendering the non-compete unlawful, illegal, unenforceable, void against public policy, etc., the discovery that I'm going to want to jump into and dig into as the attorney for that employee is going to relate to the financial information of the organization. Where do you raise your money from? What activities raise money? How much of that money that's raised actually goes to the charitable purpose? How much goes to a public purpose that supports a charitable mission versus to your executives, your board of directors, is kept internally and is for the benefit of a limited number of members? Is this the type of discovery that you as an employer, as an organization, want to be involved in? I would think that that could look very scary for a lot of not-for-profit organizations that we all know exist and generate huge profits. A lot of medical systems, and this is focused on healthcare today, but it's not just medical systems. There's other organizations that are set up as not-for-profit organizations and exempt from taxes under the IRS that in fact are very profitable organizations. And a lot of them do exist in healthcare. Healthcare is our biggest industry in the United States. Most funds generated in healthcare and defense. And so nationally, healthcare is going to be a target for this. So this is the test. This is what to look for. I'm going to give you some examples of some organizations, and these come from the FTC rule and some of the things the FTC talked about and specific cases. Some of these are cited in the FTC's commentary and some of them outside. So consider a physician hospital organization that has several private physicians working for a not-for-profit hospital, but it's engaged in business for the benefit of its physician members. This may be helping to organize contracts, for instance, under with insurance providers and payers. But the purpose of the organization, while it may be a not-for-profit organization for IRS, is really for a private benefit. That's the type of organization that that the FTC is going to look at and say, we don't think we don't believe this is an organization that we cannot regulate. This is, in fact, a corporation. How the corporation is defined, an organization that operates for the benefit of its members, stockholders or non-stockholders. That's a corporation under the FTC Act. Or consider an independent physician association made of private independent physicians in small group practices. In that case, was deemed to be organized for the pecuniary benefit of its for-profit members. And it contracted, this is another one, contracted with payers on behalf of the for-profit physician members and engaged in these services for the members paid the organization a fee. The organization was a not-for-profit organization, but it was really set up to get better payer contracts for the members. Other organizations, many healthcare systems have a for-profit and a not-for-profit portion of their services. And so where you have a partnership with for-profit entities, these may be subject to the non-compete ban as well, including where hospitals have a not-for-profit entity that essentially cedes control to the for-profit partner and generates unreasonable compensation to its insiders. I think that's going to be a big issue that we're going to look at as well. What percentage of income or profits that are derived from the organization's benefits go to a charitable purpose versus the individual benefit of its members? Here's some another example is physicians employed by for-profit staffing agencies that help to operate not-for-profit hospitals or are hired by not-for-profit hospitals. Again, this is going to create, I think, some issues with generating any traction and a challenge from the FTC. And of course, entities that lose their tax-exempt status. And this is going to be a target. If you have, to think about the changes that we've seen in the law in Florida, one exception that we have already in enforcement of non-competes is when you try, the law was changed a few years ago that you can't have a non-compete against certain medical specialties if that practice group is the only specialty group within a county. And there was a challenge that was made, I think this was a 2021 case, an oncology group was that challenged the law when somebody went out and tried to set up a second competitor. And that challenge went to court and ultimately lost based on this statute. And that was really, I think, the driving force behind the statute anyway. You have a group of well-funded individuals who are ready to challenge a particular organization. When you consider the risks, if you're a not-for-profit organization that is going to try and enforce a non-compete, and all of the financial information and financial issues that are potentially going to come up, I guess the message is you need to really make sure your house is clean, because I can see a lot of challenges and a lot of issues. And if you get one organization, you get courts looking at this all becomes public information. Now you've got further questions to answer as far as really supporting your not-for-profit mission and justifying your not-for-profit status. And if you lose that status, that'll be another way for somebody to essentially kick this out of any question of whether or not the FTC is going to have jurisdiction here, is to cause an entity to lose its not-for-profit status. Took another little picture. This is not, I only pulled this was interesting because I grew up in the Philadelphia area, and this is a hospital in Philadelphia. And there was an article that I had come across where it's Children's Hospital of Philadelphia paid the CEO $7 million in 2021, and the article went back and looked at how much charitable care the hospital had provided, and I think it was over a 3-year period. And the compensation for the CEO in 1 year, just the CEO, exceeded all of the charitable care, according to this one source, was the Philadelphia Inquirer. According to the Philadelphia Inquirer, the CEO got more money 1 year than the entire charitable mission got in 3 years. I think an organization like that's going to have a very difficult time saying we're a not-for-profit organization. We can put our physicians and staff on non-competes, and we're not going to have an issue with that. I think it's going to be very difficult to enforce those. So the message here is that tax exempt status is one factor, but it's not definitive. Certainly, when you look at what the two-part test is from the FTC and the way they've described it, simply stating that you are a tax-exempt entity or a not-for-profit entity according to IRS regulation, and hanging your hat on that for the notion that this ban is not going to apply to your organization, healthcare or otherwise, is not going to work. Now, again, there's some other exceptions. The most notable ones, banks and financial institutions, they're separately regulated. But for our purposes today, I think a lot of organizations that are registered not-for-profits are going to be on the FTC's target list. And I think given the way our system works and the amount of time and energy the FTC spent on talking about healthcare and the not-for-profit status in particular, suggests to me that some of the first enforcement actions are going to be against big not-for-profit players that try to enforce non-compete agreements. In the last webinar, we did talk about what you need to do if you're an employer. There's notice requirements if you have employees under non-competes now, to give them notice that they're no longer going to be enforceable in September. With my own clients, we're redoing contracts where we can. We're rewriting stuff, creating very strong non-solicitation, very strong anti-recruitment, anti-piracy type language, strong NDA and confidentiality provisions to protect trade secrets, protect client data, protect against patients and employees and clients being taken from the business in competition, but we're avoiding non-competes. My own my view of this is that we're going to see this eventually. So rather than running the risk of running afoul, I think we can accomplish a lot of what we want to do to really protect the legitimate business interests of the business without having this non-compete language that is going to run into trouble. All right, so moving on, how should healthcare employers in particular respond? So there are some other exceptions to the rule. Non-competes under pending litigation are going to not be affected by this rule if you are already in a lawsuit involving a non-compete. Although I will tell you, and if I have a chance to look at it, I came across a really, really interesting case because it did exactly what I thought was going to happen. And it's a court that essentially took language from the FTC rule and cited the FTC rule in the case to make a ruling that was not going to enforce a non-compete agreement. So I don't think that's the first and the last time that we're going to see that. I wish I had that case up in front of us, see if I can find it real quick, because it was... I do. I think I have it here. All right. So this is it. This is Global Med v. Jameson. It's a Virginia case from August of 2023. So this was before the FTC made the final announcement. And this was a case, it was litigation over a non-compete. It was up in the Eastern District of Virginia in federal court. And here's what the case said. Moreover, while the undersigned recognizes, the undersigned being the magistrate or the judge who wrote this opinion, recognizes the FTC's proposed rule, and this was 2023, before the final rule came out, recognizes the proposed rule may not take effect, the undersigned is also mindful of this national discussion and the suggestion that non-compete clauses are no longer in the public interest. Though not binding, the FTC's proposed rule suggests the public interest in enforcing non-compete agreements may no longer be a viable argument for litigants in cases similar to the one before the court here. Under the circumstances, the undersigned finds that the public interest does not favor granting the plaintiff's request for an injunction. So backing up a little bit of context for that quote. In order to get an injunction to enforce to enforce a non-compete and get an injunction to keep an employee from working for a competitor. And you can also go for monetary damages. That's different. That tends to be what I favor, by the way, when enforcing non-solicit and other types of agreements is monetary damages. I think courts hold a higher standard for an injunction and are more reluctant to keep people from doing something rather than saying you can continue to do it, continue to serve patients. You just have to pay essentially what amounts to a referral fee to the people that you took them from. And so what the court's saying here is that in most jurisdictions, certainly in Florida and in Nevada, where I'm also licensed, if you want to get an injunction, one of the factors you have to show that it doesn't violate the public interest or granting an injunction is in the public interest. And what the court is saying in this federal case in Virginia is that given the national discussion around the ban on non-competes and the FTC's proposed rule, and this is over a year ago, the court recognizes that the public interest is moving away from the enforcement of non-competes. And I think I predicted this in the last webinar that even before this rule goes into effect, for litigation that's going on now, although the rule is not binding, I do think that courts will look at this and say, many courts will recognize that the public consciousness is moving away from enforcement of non-competes towards other alternatives to protect business interests, trade secrets, etc. So interesting developments there. I'll be interested to see how that case and what other cases cite to that case. If you'd like more information on it, if you happen to be involved in any type of litigation like that, let me know. The other exceptions, I mentioned these in the other webinar, it doesn't affect franchisor or franchisee contracts. It doesn't affect sale of a business. If you sell a business, if you sell a healthcare practice, you are going to likely be subject to a non-compete. That's going to be totally enforceable, provided you own, I think the threshold is 25%. If you own 5%, if you have a minority interest, it may not apply. But if you own a substantial ownership interest in a healthcare or other business, and you sell, the buyers will be able to enforce a non-compete. Most jurisdictions will allow that for up to 5 years. Most of the contracts that we see, we have some deals going on right now. Often they're subject to Delaware law. So even though we're in Florida, most people make these purchase agreements in a non-compete subject to Delaware law, and Delaware will give you up to 5 years in a non-compete post-sale, and they're still going to be enforceable. Of course, I mentioned earlier, employers that are exempt from jurisdiction under the FTC Act. So next step we're going to move on to, just to give you a highlight of what alternatives are available. I've mentioned these already. Here's a little checklist. You can take these from the chart. Confidentiality, non-disclosure agreement. You can absolutely have your employees sign a confidentiality and non-disclosure agreement so that they can't share information with a subsequent employer. And we have this come up sometimes. I have some actions going on right now, some litigation involving former employees who took private confidential client lists and contact information, pricing information, and used that to compete against their former employer. And that is still going to be allowed, and that will be actionable. Non-solicitation, anti-piracy agreements. You can't go take former patients and people from your former employer. Nobody wants to hire a new doctor, dentist, professional to come into their practice, somebody who doesn't have a relationship with their people, introduce them, get them acclimated into serving the patients of the practice, and then have that person run off with their patients. That's always a risk, and the court's going to allow you to take action to enforce that. No hire, no recruitment agreements, same thing. You can't go in somewhere and take you can't take our employees and go somewhere else. The way I like to deal with that, again, is usually with monetary damages, akin to if you take one of my staff or employees or my clients' folks, then there's going to be a monetary damage component similar to what I might have to pay a recruiting agency or somebody else to bring another employee to me. If you're going to take patients, if you're going to take a client, depending on the value of those clients, you may pay a certain amount for taking those clients. Training repayment agreements. These are agreements that are set up that say, we're going to provide you with a certain amount of initial training within the first 3 months, 6 months, however long that you're employed with us. And you agree that if you leave in, say, maybe under a year or within a certain amount of time, you're going to repay us a certain dollar amount. These have to be reasonable. The FTC talks about these at length. They call them traps, which is not a good acronym for these arrangements, but they are allowed Again, as long as they're reasonable. So you need a reasonable dollar amount on the training that you provide. Garden leave provisions, these are interesting. These are essentially where you pay the employee who leaves not to work somewhere else. It's similar, you see this sometimes in a severance agreement. You used to see a severance agreement that you got 3 or 6 months pay, but you can't compete for 2 years. The reason I have this as a maybe is that the agreement to keep somebody from working with a competitor post-employment is not enforceable, but recall that I said that during employment, it is enforceable. So the way I see employers being able to enforce these is to continue the employment contract, and the employment contract will continue for 3 months, 6 months, a year, and the employee will get paid during the time that they are still considered an employee, but they'll be paid to stay home. So you're paying them to stay on the sidelines versus post-employment, which potentially runs into trouble. It seems a little bit like semantics, but I have a sense that that's where that is going to land. Here's some examples of some things you may try to do to get around the non-compete ban. Put it in some other clothing or another description and run into problems. If you have a non-disclosure agreement that bars someone from disclosing in a future job any information that's usable in the industry in which they work. An example of this in healthcare context might be a technician, for instance, who operates MRI equipment being unable to use any training or any information that they've received in advancement of their career, their profession, in a subsequent job. That's going to be probably too broad. It's going to have to be something specialized that they learn in the business that's not common knowledge elsewhere and doesn't represent just a technological advancement. A non-solicit clause that prohibits a doctor from treating anyone who is formerly a patient or a prospective patient or who could become a patient of the former employer. The argument there, of course, is going to be, well, almost anybody could be a prospective patient of a practice, depending on what type of practice that is. It's, let's say it's a general dentistry or a internist, a family physician, but a pediatrician, any type of general practitioner. Almost anybody could be a potential patient. So restricting that, having a restriction that is that broad is likely going to run into problems. Here's another one. This was an actual example. It was in the FTC. In the FTC commentary was a training repayment agreement, a trap agreement that required nurses to work for 3 years, or else if they left under 3 years of employment, they'd have to repay everything they earned, plus pay future profits, attorney's fees, arbitration costs, etc., to their employer. And that was ruled to be the type of agreement that would not be enforceable. It would run afoul of the post-employment restriction on working for a competitor. So you get the idea that you may try to draft around these, but the FTC and I think courts in general are going to look at the substance of what the agreement does. If it restricts post-employment competition unreasonably, and if it does, you're going to run into issues with them. For the attorneys who are joining or anybody who works with other clients, you should be, at this point, I should be informing clients that the rule looks like it's going to take effect in September, unless we get a national ban or a national injunction, which I don't think is going to happen. Employers should be prepared for this. They should be sending out the required notice. I put the form of the notice in the last set of slides that we did a couple of months ago when the rule was first announced. There is I recommend taking the notice that the FTC says to use if you have employees on non-competes. Use that exact notice. It's actually translated in several different languages if you need to do that. Don't get creative. Don't try to create your own language. Just use the FTC notice. Give it to people, or even better, get with your attorney and redraft these agreements to protect your concerns, but take out the non-compete language that's going to run into issues. So I told you earlier, I mentioned that there were some arguments that are going through the courts right now. There's a few cases. The main one is the Ryan case, and the plaintiffs that were in the Chamber of Commerce case were essentially told by the court to intervene in Ryan, so this could all be dealt with in one case in Texas. And listed up here on the slides, some of the arguments that have been raised. One is that the FTC lacks authority generally to engage in substantive rulemaking, as opposed to procedural rules, which are rules in just how to carry out the intent of the statute. I don't see that being successful because the FTC brings substantive actions all the time to enforce and shut down organizations for unfair and deceptive trade practices. And in fact, the FTC already dipped its toe into this water by suing a couple of companies in January of 2023 based on unfair and deceptive practices. And I'm sure they did this to lay the foundation for this. They went after companies who they believed had onerous and unwarranted non-compete agreements where all the employees, one of them was a glass or a window company, every employee was forced to sign a non-compete agreement, and the FTC went after not only the companies, this is interesting, but they went after the executives as well. And they fined the companies and fined the executives. I don't know if it was publicly disclosed, but they did that a few days before they announced the proposed rule that led to the final rule. So the FTC's already done this, and they've already gone after businesses for unfair non-compete agreements and policies. There's another question that the rule is barred by the major questions doctrine. I would suggest that this is something you're into. Maybe you go read the commentary at the FTC and read the case law or read the cases on this. Major questions doctrine is essentially says, and I'm no expert in this area, but as I understand it, it essentially says that this is an area of great political significance, and the FTC should not act and should reserve action for Congress to act. And as I mentioned earlier, there is a bipartisan bill heading through the Senate and through the House that seems to have a good amount of support, where we may actually see a statute anyway. Impermissible delegation of legislative authority. Okay, that's another argument. The rule is inconsistent with the FTC Act. I raised this last time. I haven't seen this argument come up much, but it did come up in the commentary in the Ryan case or in the Chamber of Commerce case. And it was one of the cases, and the court said, well, you didn't initially raise this, so I'm not going to consider the argument. It'd be worth maybe going back and looking at it. There's Fifth Amendment concerns, the contracts that are already in place. Does the FTC have the right to affect contracts that have already been signed and are not grandfathered into the rule? As I mentioned earlier, agreements that have already been signed are going to be considered unenforceable by the FTC after the rule goes into final effect in September. I believe the FTC's position on that is going to be that this contract was fair and unenforceable anyway. The rule just articulates our view of the unfair practice under the FTC Act, which we are entirely entitled to regulate. And the rule's just essentially stating in words what we already believe the law to be and our view on these types of agreements. And that's how they're going to get around that. The rule is arbitrary and capricious. Again, maybe go read the cases if you want to see how that argument is expanded upon. And then there's some rules, some arguments that the FTC has violated, has exceeded its constitutional authority because this is something where Congress should have acted instead of the FTC commissioners. Again, I don't think any of these are going to get, they got a little bit of traction in Texas. There is some position in Texas that you might say, well, if we're in Texas, we don't have to follow this. But I think it's risky. And if you are in Texas and you're not planning to redo your agreements or follow the rule, you certainly want to make sure that you don't have a clause that makes you subject to jurisdiction somewhere else, because you may run afoul of it anyway. I've seen several non-compete agreements that are drafted, maybe by folks that had a reason for doing it when they did it. Maybe it's a national employer, maybe not a lot of thought was given, maybe it's something they pulled off the internet. But I had a non-compete agreement a couple of years ago that I looked at that was dealt with a couple of folks here in Florida and was subject to New Jersey law, where it would have not been enforceable. I don't know why you would write something, a contract, and put non-compete provisions subject to another state's jurisdiction where it's not going to be enforced, but that's the way it was written, and it's not uncommon to see that. All right, so I think we got to the end. I mentioned I may I'll give you an idea. I want to see if there's any questions. We've got a couple of minutes. And I want to go back to something I think would be really interesting. But in the meantime, if there are questions, I'm perfectly happy to field those. I was just, as I was looking at some of this stuff and looking at the cases, I was thinking of the types of questions that you might ask if you got into this question about whether a entity that's organized as an IRS not-for-profit organization is in fact a not-for-profit entity under the two-part test articulated by the FTC. And you might have questions such as interrogatories to a party that ask the employer to describe the primary activities of the organization and how those activities serve its stated or charitable purpose, identify all sources of income for the organization over the last several years, including donations, grants, fees for services, and other revenue, describe the process the company or organization uses to determine how net proceeds are allocated, and specifying the public or charitable purposes served by those allocations, provide explanation of the organization's structure, including the roles and responsibilities of the members and any for-profit entities affiliated with the organization or benefiting from the organization's activities, identify individuals who have received compensation or financial benefits or other types of benefits from the organization, including the nature and the amount of benefits. That's where we're getting into salary and inurement concerns potentially, which is a bad word under IRS inquiry. Describe any partnerships or joint ventures the organization entered with for-profit entities and the agreements and the benefits received by each party and the contribution by each party, and of course documents that go along with that. This could make for a very interesting issue to see how far a court would allow a party to inquire into an organization's finances to determine whether it's subject to this rule. So stand by for more. With that, I think we have finished for today. We covered the material I wanted. Have time for any questions if there are any. And if you don't think of the question now and you want to throw it at me at a later time, shoot an email or reach out to me by phone or email. Tony, back to you. Actually, I got some questions up here. Let's see. All right, so here's a question somebody posted. How do you draft? It looks like a non-solicitation clause to ensure that it's enforceable and not overly vague. Specifically, what language and provisions should we include to clearly define the scope and limitations of non-solicitation clauses to protect business interests without conflicting with the new regulations? That's a great question. So more specific is better. The best would be, let's take an organization. I'm going to use healthcare. I'm just going to consider patients, but you may have other, you may have referral sources and other organizations as well, but let's focus on patients. The easiest would be you will not, you could attach, not attach, but essentially refer to a list of patients. You will not, if you leave our employment for the next year or 2 years, you agree not to serve any patients who were patients of the practice at the time you left. That's pretty specific. It's a pretty narrow group. They're patients of the practice and you won't serve them. Now, what happens if you do serve them? Two things. I mentioned this earlier. One is you could try to go for an injunction, which I think is tough because you run into this argument, well, the patient wants to work with this doctor. You see the same thing in accounting. We see the same thing in law. What the accountants often do, and I've done this with other businesses, is if you're going to leave, I have another client, we got into non-compete litigation and we ended up redrafting and going this direction. If you're going to take one of our patients, you're going to pay us 20% of the fees that the patient pays you over the next year. So the patient can go with you, but you're going to pay us because it costs us marketing dollars and administrative dollars to get that patient to hire you, to bring them in. And now you took them, so you're going to pay us essentially a referral fee for each patient that you take. You could refer to your existing patients that are in your database. You could broaden it and say anybody who is a patient, because folks could plan, right? They could say, well, they'd start telling people, hey, I'm going to leave the practice. So you ought to terminate your relationship with the practice. So when I leave, you're not a patient. That's how you try to get around it. So you might say, you will not, for the 2 years after you leave our practice, you will not serve anybody who was a patient during any of the 6 months or any of the year prior to your termination date with our practice. So that gets a little bit broader, but I think it's still specific enough. You could go back further. You could say, get it a little bit broader, and you could say, for 2 years after you leave the practice, you will not serve anybody who was a patient at any time you worked with our practice. Well, that might work if it's somebody that was with the practice for a couple of years, but it might be a little bit tougher if it's somebody who was with the practice for 10 years and the patient hadn't been a patient for 8 years. You may get into some issues with that, but it's a broader way to draft it. So what I like to do with clients is specifically spend time. What are we trying to accomplish? What it may depend on your business type. In healthcare, it may depend on the type of patient. Some patients may only be seen once a year or once every 2 years, and so it's not somebody you see regularly versus your family physician who you see or your family members see on a regular basis. You could also say you could make it broader and say you're not going to service any patients or any family members, direct family members, to be spouse, child, mother, father, etc., of anyone who is a patient of our practice for 1 year or 2 years after you leave our practice. That's getting a little bit broader. It's still a specifically defined group, but you're broadening it and you're creating maybe a little bit more gray area, but I think I would go for that in the right context. Again, in a family practice, I'd probably go for it. Specialty practice, some other types of businesses, maybe not. I have other business clients that provide organizational services, let's say like home health care, stuff where they have agreements with other organizations, and we may do a list. This list of entities, you agree, this list of businesses, you agree not to do business with them. We have specific protected relationships with this group. See Exhibit A, maybe it's 25 organizations. Let's say I used to have a physical therapy group where they had relationships with facilities, where they went in and did in facility, they did services in the facility. You will not go to those facilities for this amount of time. I think that would be enforceable. It's when you make it more broad and it's tougher to define exactly who at the time you contract is restricted is when you're going to run into problems. I hope that was helpful and answered your question.